How many criminal trials have you been a defense attorney in?
Including this one.
Including this one?
One criminal trial, including this one.
One criminal trial?
One criminal trial.
This was your first criminal trial?
This was being thrown into the deep end. Yes, my first criminal trial.
How does that happen?
It's kind of, I've been practicing as a criminal defense attorney for maybe 2.5 years now. I guess we're closing in on 3. So I had only been doing this about 6 months when this trial started. And fortunately, Jay Apt, who I work with here, just gave me the opportunity to participate in it. I had done the bulk of the review of the evidence, and it just seemed natural that I would be the one to sit in there. And fortunately, I say thrown into the deep end, but the reality is I was in trial with Brian Steele, Keith Adams, the Matthews, Bruce Harvey, and they were all there to back me up. So I had the confidence to know that if I missed something, if I didn't object when I should have objected, or any other issues, I knew they would be there to do that. And I got to learn from them, and I got to watch them, and hopefully become a better criminal defense attorney over the 2 years of trial.
Your background before getting into criminal defense was what, as a lawyer?
Intellectual property, patent litigation, transactional work related to intellectual property. So I was still in a courtroom, but almost exclusively federal court. The trials I'd participated in had been bench trials. So not only was this my first criminal, this was my first jury trial.
The stakes, I've got to imagine, are much higher too when you get into criminal defense.
To me, they are. I don't know that anyone would agree with that. I mean, I had billion-dollar litigations or multi-billion-dollar litigations I was involved with.
But so now
I thought, like, okay, I've been involved in high-stakes stuff, but it's nothing compared to when someone's life is on the line, when someone's looking at prison. So yes, this is the highest stakes trial I've been involved in.
Did that weigh on you over the course of this case?
Constantly weighed on me. And that is why I did everything I could to talk to all of these people that are in court with me, to talk to other people, to rely on Jay Apt and Katie Hingerty, who I work with here, for advice and guidance and help on how to get through this trial. And I just knew that with someone's life on the line, with Diamante's life on the line, it was up to me to do everything in my power to save him.
Now that this case is finished, or at least I should say, now that your involvement with this case has come to a close, and you look back on it now, how does it compare in reality to what you expected it would be going into it?
I don't think this case went as expected for anyone involved, be they defendant, the state, the judge, staff attorneys, everyone involved. This case is unlike any normal civil or criminal case. The amount of bizarre and crazy things that happened over the course of this case, the length of the case, 10 months of jury selection, a judge who's recused and replaced mid-trial by another judge. I mean, there are so many things that happen. The side characters in the case, the witnesses. Nothing in this case went as expected.
This is known as Georgia's longest-lasting criminal trial. Jury selection started in January of 2023. The final verdicts for your client came just earlier this week.
Yes.
That's a 2-year span.
It is. And it's a remarkable length for a case. The 10 months of jury selection, I would imagine, are unprecedented. I haven't checked, but I can't imagine anything came close. And then a jury sitting for a year is a lot to ask of our citizenry.
What's the impact on the system of a case that lasts this long?
Well, what you had was, and I don't think people appreciate this, when we're in trial for 2 years, Diamante is not our only client. We have other clients. Now, fortunately, a lot of them, if not most, are out on bond. But there's scores of our clients that are sitting in jail waiting for trial, and they can't get their trial because their attorney is in trial. We can only do one trial at a time. That's just our clients. Replicate this over and over by the number of defense attorneys involved in the case. Look at the judicial resources dedicated to this case. Look at the resources of the DA's office dedicated to this case. Look at the resources of the Fulton County Sheriff's Office and Cobb County involved in this case. And it was a huge diversion of resources that could have been put to other uses.
You think the YSL case slowed the pace of justice in Metro Atlanta?
Well, I don't just think that, I know that. The YSL case bogged down courts throughout Metro Atlanta, all the surrounding counties, and even courts as far away as Cairo, Augusta. All of them were suffering the effects of attorneys that have cases in those courts being tied up here in YSL.
I'd imagine there are some, including perhaps folks who are more prosecutorially aligned, who would say, look, we allege that a crime was committed and you've got to do whatever it takes, no matter how long it takes, to bring that case to its conclusion. What do you say to that?
I would absolutely agree that that's the case, but you can do it in an efficient manner, and you can do it in a manner that perhaps could yield better results for the prosecutor. I don't think it was in the prosecution's interest to drag this case out over a year. If the prosecution is concerned, for example, with the murder of Donovan Thomas, then try who you suspect did that in a murder trial. The murder of Shamel Drinks, try those people in a murder trial. You don't need to make this massive RICO trial that takes a year. I know the Prosecution Council of Georgia likes RICO because they say, quote unquote, you can tell the whole story. So if you like RICO, be efficient about it. Try the case in 3 months. I believe that the judge in this case said that for the other 11 defendants that have yet to be tried, she's going to try it in 90 days. So this could have been done faster. It could have been done more efficiently, maybe yielding better results for the prosecution, even though, of course, my client was not guilty of any of these charges, but perhaps they could have gotten better results. So it's in no one's interest to drag this out for a year.
You brought up Donovan Thomas. I think sometimes the facts of, as alleged in the indictment, the facts of this case get overshadowed over the course of this incredibly long trial, and the social media and live blogging and all of the controversy and unusual things that occurred in the course of this case, especially when viewed through the lens of what typically happens inside of a courtroom. But there are serious allegations at the heart of this case. Donovan Thomas was killed in 2015. Your client, Diamante Kendrick, was accused of killing him. The jury acquitted Diamante Kendrick of that charge, but that's a serious charge nonetheless. What do you say to Donovan Thomas's family now?
Well, they have not gotten justice, but they would not have gotten justice if my client somehow would have been convicted of this, because my client was not involved in that murder of Donovan Thomas. I think anyone that watched this trial would have a pretty good idea of who was more likely involved in that murder of Donovan Thomas. And I think it's just a shame that the investigation of that murder was so sloppy, that leads were not followed, that, for example, as Mr. Steele always comes back to, this videotape of the McDonald's of an alleged meetup wasn't gotten. There were a lot of leads that were not followed or followed up on regards to the murder of Donovan Thomas. So as I said in my closing, I feel for the family of Donovan Thomas. It's terrible to lose a loved one. I cannot imagine what would happen if I lost one of my 5 children. But this trial was never going to get justice for Donovan Thomas.
Let's talk about your client now. What was Diamante Kendrick's experience throughout this trial?
Well, his experience I don't think was that different from hundreds, if not thousands of people who are locked up in Rice Street, denied bond, and have to spend time at the Rice Street jail who haven't been convicted of anything. And we need significant reform on that. I know that's not exactly your question, that's another issue. But he's locked up in the jail. You can't sleep in there. You can't see your family. There are no visitors since COVID. So the only visits you get with family are by video or by phone. It's not, and it's a terrible facility, as I don't need to probably tell most of your viewers. So he had that. He had this weighing over his head. He gets woken up at 4 to 6 a.m. every day, transported to court, spends all day at court, goes back. If he's lucky, he gets 4 or 5 hours, 6 hours of sleep, although I don't know how restive it is. It's very difficult. And the fact that he was able to keep up his spirits throughout that and by the way, the public helped with that a lot, is amazing and probably more than I could have done.
And he was injured at least once in an altercation inside of the Rice Street facility while he was housed there, wasn't he?
Yeah, I mean, he had a couple of incidents there. The most recent incident was last Sunday night. He had an altercation. Now, that wasn't at Rice Street. That was at the Annex in South Fulton that's in Union City. But he had an altercation there. And that's the issue, though. If you are locked up in Rice Street or in the Fulton County jail system for 2.5 years, and you are accused of gang charges, you are going to have altercations. There are going to be issues that pop up while you're locked up in that jail. And of course, that happened to him.
I touched on this earlier, but I want to put it really squarely to you again, because a lot of people watch these interviews, and a lot of people come to a case like this with different preconceptions of what might be the just outcome here. There are going to be folks, many of whom probably follow this case closely online, and who probably thought that the outcome that you all reached was a just one. There are also going to be people who look at this, who read the indictment, who hear this is a guy who's accused of being involved in a criminal street gang, accused of murder, accused of violating the state RICO statute, among other serious charges, and they'll say that the jury got it wrong. What do you say to those people?
Well, I would say to them that if they are wrongly accused of a crime, that I would hope whoever defends them forces the state to meet their constitutional burden and show that there's guilt beyond a reasonable doubt. The state failed to do that here. I don't believe they could have done that here, given the dearth of evidence and my client's innocence. And I also hope that they understand that when you get in there and you fight for people, regardless of what they're accused of, I don't care if it's murder, I don't care if it's racketeering, and honestly, if it's child molestation or some other incredibly heinous allegation, when you defend those people, you don't just protect those people's rights. You support the Constitution and you protect the rights of everybody else. It stops the police from doing unlawful searches and seizures of your home, and it keeps the government under control. And I think that a lot of people that may say, well, the jury got it wrong, these guys should have been convicted. I think if a lot of those people think about it, they would also want the state's feet to be held to the fire and for everyone's constitutional rights to be respected.
What do you think the legacy of this case will be?
That's a very difficult question because I'm torn between cynicism and hope. My hope would be that the state has learned, at least listening to what some of these jurors have said, that the use of artists, and we haven't talked about this, but the use of artists and rappers' artistic expression against them is not only is it wrong, not only does it infringe upon their First Amendment rights, but it will not yield success in a lot of cases. And it didn't yield success in this case. So maybe they'll think twice before using lyrics against them. Maybe in future cases, they will be more considerate of the time of the citizens who get put on jury duty. Maybe they will understand that the resources of our justice system, including the DA's office and the sheriff's office and the judiciary, can be put to better uses than these massive racketeering charges. So I certainly hope that that is some of the legacy of this case, a more efficient system.
You said you're torn between a more optimistic and a more cynical answer to that question. You gave the optimistic version.
Yeah.
What's the cynical one that you're wrestling with?
Nothing changes. You know, I would hope that's not the case. I would hope that lyrics aren't used against people anymore. But given the amount of times that lyrics are used against people of color, and by the way, they're only used against people of color, the number of times lyrics are used, I don't know that it's going to go away. Georgia's RICO law needs serious reform, especially the conspiracy portion of the RICO statute. So my cynical answer is that's not going to be reformed or changed. It's very rare that you don't win re-election by reforming the criminal justice system, by reforming bond, by reforming bail, by pulling back on statutes. So, and the DA's office, maybe they won't change it all too.
You mentioned the use of rap lyrics as evidence in a prosecution. you have been vocal in your opposition of that. You've argued that it violates First Amendment protections of speech. There are also going to be those who see it from the other side and who feel as though these are written expressions of real life. Sometimes, oftentimes in music, they're presented as real life. So somebody might say, well, why not use them as evidence? This is like a confession.
Yeah, and I believe that in her press conference after the indictment and the arrest, Madam DA Fani Willis said, if you are going to confess over a beat, I'm going to use that against you. I'm paraphrasing. But the reality is that assumes that people that rap and people of color have no creativity, are not intelligent enough to make up things, make up stories. No one accuses Bob Dylan of inhabiting every character that he creates. It also ignores the fact that the record labels, the music industry, this is what sells. Now, think of that what you will. That's an entirely different issue. But the labels want this, and so there's a demand, and so people create this type of music. But to say that that is necessarily confessional, I find to be tremendously offensive. So if you want to use that against people in trial, I believe that you have to show some kind of a nexus, some connection between the lyrics specifically and the alleged crime. And it's certainly against Diamante Kendrick. They did not, who goes by Yak Gotti, they didn't show any connection between the lyrics that he would rap and the crimes that they were charging him with. Yet, they still wanted to use his lyrics against him.
So it sounds like what you're advocating for isn't a blanket ban on the use of lyrics as evidence, but rather a hemming in of when they can be used. Is that right?
That's exactly right. And if you look at the RAP Act that's in Congress and hopefully one day in Georgia, it doesn't ban the use of lyrics. It doesn't ban the use of artistic expression. But what it does is it raises the bar before they can be brought in and used against people in court. And that's all I'm asking for.
And the RAP Act was introduced by Georgia Representative Hank Johnson.
It was. He was one of the co-sponsors of that act.
And that has now passed. It has become law.
It has not passed. And I don't believe it's even made it out of committee. And of course, when this Congress ends, it will have to be reintroduced in the next Congress. And so what I'm hoping to do is use the small platform in my 15 minutes of semi-fame to try to push for that. And I'm going to continue to advocate for passage of the RAP Act.
This was not the only major RICO case in Atlanta this year. The YSL case was part of, in some ways, a twin-track major RICO case path through the Fulton County justice system. The other component of that was the ongoing election interference case against now President-elect Donald Trump and a number of co-defendants. How do you think the YSL case and its ultimate outcome will potentially impact that other major RICO case here?
You know, I don't know that we'll have any direct impact or maybe even indirect impact on that case. That case is on such a different track with such a different situation, especially because that case is likely to go away now that President-elect Trump is going to become president. So I expect that case to fizzle away. But what it does show, again, is the breadth of the Georgia RICO Act. It's far broader than the federal act. And I mean, I used to explain to people that under Georgia RICO conspiracy law, if you were to get on Facebook and you were to say, I completely support what President Trump did, this election was stolen, his seeking the 12,000 votes was all totally legitimate, that's an overt act in furtherance of the conspiracy, and you could possibly be named in a Georgia RICO conspiracy indictment.
If you could prove some other predicate acts, too.
But the predicate acts, if we're going to get detailed, those predicate acts do not need to be committed by that person that was charged. So, for example, let's look at Diamante Kendrick. The state, to prove RICO conspiracy, does not have to show that Diamante Kendrick did any of the predicate acts. As a matter of fact, they don't have to show that he did any of the overt acts. All they have to show is that there was a conspiracy and that he willingly and knowingly joined it. So, to get someone, back to the President Trump analogy, to get someone for that, you would just have to show that there was a conspiracy involving President-elect Trump and that you willingly and knowingly joined it. And that is, honestly, a very easy thing to show.
You seem like somebody who thinks Georgia's RICO Act is, as it's constituted right now, way too broad.
That's correct. You picked that up.
Casts way too wide a net, in your view.
It does.
I want to land this conversation here. We're talking about Georgia's RICO Act. You've seen the inside of a history-making, in some ways precedent-setting, RICO case here in Georgia. You seem like somebody who is frustrated by the way this case was handled, by how long it took, and by how many resources it took to get it to a verdict. Is that accurate?
That's completely accurate.
Who's responsible for that?
Ultimately, it is the responsibility of the judge that managed this case, as well as the DA's office. Basically, you have a judge that did not put any type of a check until Judge Whitaker. Judge Whitaker's done a great job. But until Judge Whitaker came aboard, you have a judge that was not willing to put any type of efficient management on the case.
You're talking about Judge Glanville.
I'm talking about Chief Judge Glanville, who we had 28 defendants, refused to sever it out into manageable chunks, which is, by the way, what would have happened in a federal case. They would never try 28 people. They would sever that out. So he refused to sever the cases out. He didn't put any type of a clock or any type of time management on the state. And then the state, who, thinking that would be helpful to them, just took it and ran with it. So I think it was a combination of the two. Was the defense at all to blame? I'm just going to say no, because I repeatedly, and not just me, filed motions to try to move this case along, to try to put some efficiency there, to try to sever defendants out and make it more manageable, all of which were denied. So I will not take blame for that. I think it's fully on a situation where you have a judge and a DA working hand in hand to reach what eventually was a just outcome, but not because of the actions of either of those parties.
I asked you this earlier, but I want to end with asking you it again following that answer. Do you think anything will change?
Boy, no.
Why?
I don't see much change over my lifetime. I would like for things to change. Do I think the DA's office is going to change? Do I think they're going to stop using RICO? No. It is too powerful a tool as it's currently written under the hands of the DA's office. And I'm involved in RICO cases. There are RICO cases all over the state. And what happens is, because that law is so strong, they're able to force people to plead out, and they're able to put people away in prison. So I don't expect any DA's office to change. Will we have another case that's a year long? I don't think so. So that part we probably will see change. Will there be another jury selection that takes 10 months? I don't think so. So for example, in this case with Judge Whitaker taking over, she was going to insist on a 90-day case. So maybe I'm being too cynical. Maybe some things will change. Will the things that really go directly to the lives of people and the use of RICO as this ridiculously powerful tool change that? I don't think so.
11 Alive News reached out to District Attorney Fonnie Willis and Judge Ural Glanville. Neither responded to a request for comment.